constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay as enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 1(8) of the High Court Civil Procedure Rules 2004, CI 47, that enjoins high courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. not even the president and vice president are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution.